This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to explain why actual evidence is needed to defeat a motion for summary judgment. And although a doctor is a professional, the doctor is not a lawyer, and will find that only a fool represents herself. Dr. Megan Rust appealed, acting as her own attorney, from the district court's summary judgment in favor of Laboratory Corporation of America in her action alleging 5 California state law contract claims. In Megan Rust, M.D. versus Laboratory Corporation of America, an August 23, 2024 decision of the United States Courts of Appeal for the Ninth Circuit, the Ninth Circuit resolved the issues raised by Dr. Rust. 1. The Ninth Circuit declined to address Dr. Rust's argument that this action concerns whistleblower retaliation because she raised it for the first time on appeal, and 2. Labcorp's submission of excerpted deposition transcripts rather than complete transcripts in support of its summary judgment motion was entirely appropriate. A party asserting a fact cannot be or is genuinely disputed, must support the assertion by citing to particular parts of materials in the record, including depositions. Dr. Rust failed to produce evidence to controvert Labcorp's evidence, nor did she identify any specific material information in the omitted portions of the transcripts creating a genuine dispute. If the party moving for summary judgment meets its initial burden of identifying for the court those portions of the materials on file that it believes demonstrates the absence of any genuine issue of material fact, then the non-moving party must set forth by affidavit or as otherwise provided in Rule 56 specific facts showing that there is a genuine issue for trial. The district judge is not required to comb the record to find some reason to deny a motion for summary judgment, even if it feels for a pro se party like Dr. Rust, who was representing herself. Only disputes over facts that might affect the outcome of the suit under the governing law will properly preclude the entry of summary judgment. The Ninth Circuit concluded that the district court did not err in granting summary judgment on Dr. Rust's first claim, breach of contract. The district court properly concluded 1. Extrinsic evidence in the form of Dr. Rust's acquisition of full-time malpractice insurance coverage, and 2. Labcorp's supposed but uncorroborated oral statements contracting Dr. Rust for full-time work was barred under the parole evidence rule because the parties executed a written integrated agreement for part-time professional pathology services as requested. And 3, when parties enter into an integrated written agreement, extrinsic evidence may not be relied upon to alter or add to the terms of the writing. Dr. Rust waived any argument of error regarding summary judgment on her claim of breach of the implied covenant of good faith and fair dealing because her summary judgment briefing affirmatively conceded that no genuine dispute of material fact existed with respect to that claim. Dr. Rust's conclusory, self-serving deposition testimony that Labcorp interfered with another business opportunity standing alone lacks detailed facts and any supporting evidence, so it is insufficient to create a genuine issue of material fact. Dr. Rust did not point to evidence in the record other than her own declaration showing a triable issue of material fact, and that just was not enough. And then she accused the judge of being biased, but the fact that a judge rules against Dr. Rust is not evidence that the district court judge exhibited bias or engaged in judicial misconduct. Judicial rulings alone almost never constitute a valid basis for a bias or partiality motion. In my opinion, insurance is a contract, and she proved that she had that insurance, but it wasn't sufficient to prove the rest of the contract she claimed. Failure to prove the contract destroyed the entire action by Dr. Rust in pro se. She was faced with a motion for summary judgment and failed to produce any evidence that established an issue of fact to defeat Labcorp's motion for summary judgment and prove the maxim that a person who acts as her own attorney has a fool for a client. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. Please tell your friends and colleagues about the blog so that they too can subscribe. And if you and your colleagues subscribe, you will all have access and notice of every blog posting, usually 5 or 6 a week. And you'll have access to the more than 4,850 blog postings. If you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider, for a small fee, subscribing to my Substack publication. Thank you for your attention.